Good afternoon. My name is Colette Tevet. I'm the Public Defense Training and Reform Director for NACDL, and I'm very delighted to have to present Deja Vishny and former Detective Jim Trainum present to you today about coerced confessions. The webinar today is being brought to you by the Bureau of Justice Assistance, a grant that we had, and we're delighted that we could bring it to many of you for free. Today you're going to be hearing about one of the things that we all struggle with as criminal defense attorneys. What do you do when your client confesses? It is one of the most difficult types of cases to defend. Judges, juries, prosecutors, and even defense lawyers have a hard time sometimes believing, why would an innocent man confess to a crime that they didn't commit? Deja Vishny and James Trainum will talk to you today about how to defend these cases. Using the Brendan Dassey case as part of this presentation, for many of us who watched the Netflix documentary, The Making of a Murderer, we were all devastated to see Brendan Dassey confess potentially to a crime that he didn't commit. Deja will be talking about how to litigate motions to suppress due to Miranda violations, involuntariness, lack of reliability. James Trainum will talk about the effect of contamination on statement evidence and how to evaluate a confession for lack of reliability. Both will discuss how to present this testimony to judges, to juries in cross-examination, opening statements through closing arguments, including how to present best expert testimony. Many of you in the audience know Deja Vishny because she's been on the board of directors for NACDL for many, many years and has been really instrumental in providing quality CLE to thousands of defenders nationwide for the last 30 years. For the past 35 years, she's been a public defender with the Wisconsin State Public Defender Office, where she's the deputy training director, as well as the head of the Homicide group, which is statewide. She has taught all over the country. She has been a faculty member at the National Criminal Defense College since 1998. She teaches trial advocacy in Marquette University Law School, and she's co-chaired the False Confession Program at the inaugural session of the National Forensic College at Cardozo Law School. She serves on the board of directors here at NACDL and has previously served on the board for the state of Wisconsin Criminal Law Section. Very excited to announce that Deja Vishny has also just written and published a book called Suppressing Criminal Evidence. It is an amazing book, and it really is a step-by-step guide on how to litigate motions to suppress, starting with the understanding what some of the constitutional issues are. She gives true-life examples. She gives practice motions, which I'm always thrilled about. She gives practice pattern cross-examination examples. So it's pretty much a go-to how to litigate motions to suppress on a myriad of issues. And she practices what she preaches, because just about 2 weeks ago, got a first-degree murder case dismissed after successfully litigating a motion to suppress on an eyewitness identification case, using the most up-to-date research and case law, and convinced a judge and then ultimately the prosecution that the eyewitness identification was coerced, or was tainted, I should say, and ultimately it was suppressed. James Trainum is it's one of these folks that you don't always see at NACDL. He's a former detective here from Washington, D.C. Metropolitan Police Department, where he worked for 27 years, the last 19, in which he was assigned to the Homicide branch. He's created and was the director of the department's Violent Crime Case Review Project, which oversaw the review of old cold homicide cases. James has presented at universities, police academies, prosecutors' offices, legislative bodies, conferences on all topics ranging from cold case investigation, criminal profiling, avoiding investigative pitfalls, the need for videotaping of interrogations, police reform issues, and false confessions. He has written on this. The materials I think we've provided you links to them. But one of the things that I found so fascinating and wonderful about James Trainum is that when he realized that he may have been subject to a coerced confession or using psychological interrogation techniques that would be unduly difficult for a client to withstand the interrogation, he said, I'm going to become an expert, and he is an expert on false confessions and interrogations. He's the author also of How the Police Generate False Confessions, an inside look at the interrogation room, which will be released in July. And at the time that it is released, we will send out information about how you can purchase James' book as well. So with that, I'm really delighted to present these the experts in false confessions, Deja Vishny and James Trainum. Thank you so much.
Thank you. You know, this cartoon really reminds me of doing confession cases and what our clients are like. Colette Tevette, I want to thank you for that very nice introduction. I'm really pleased to be here for NACDL. I also want to let all you public defenders out there know that if you are interested in getting the Suppressing Criminal Evidence book published by James Publishing, that you can actually get a 30% discount by contacting the publisher. You can also get a 20% discount online by entering the code SCE20. I used to detest confession cases because they made me so afraid that I was going to lose. And I really didn't understand when I was a very young public defender how confessions could be false. Now, of course, I'm ancient, so that was eons ago before a lot of the research was done on this particular issue. But throughout the 80s and 90s, a huge body of research came out that we all need to familiarize ourselves with. Why is it that our clients are like the client in this cartoon? They can't see that their confession was what was going to put them away. And that's exactly what happened to Brendan Dassey, who I'm sure many of you are familiar with from the Making a Murderer movie. So one of the things that we have to do is to educate ourselves, judges, juries, that police interrogation is not a search for the truth. It's a quest for a confession. What we have to do is learn how this occurs and what we can do about it. The best way to start is by learning about how police interrogate individuals. The largest training company in the United States is called Reed and Associates. They have a very good website if you want to explore what they've done. Their book, Criminal Interrogation and Confessions, is currently in its 5th edition. But when it was first published, its methodology for obtaining confessions by using psychological methods, which is still at use today, was considered so coercive that it's mentioned numerous times in the Miranda decision. So what is the Reed interviewing technique or interrogation technique? It consists of 3 basic parts. They would say 2, but I really think it's 3. A behavior description interview, bait questions, and what they call the 9 steps. And I'm not going to go through all of this. There are numerous articles that you can read in various magazines, books about the Reed technique, but just so you briefly understand what it's all about. What they instruct people to do is to start by interviewing a suspect, and they have a series of 17 very structured questions that should be asked. The really amazing thing, some of these questions have absolutely nothing to do with really investigating a crime. For example, what they tell a police interrogator to do is to ask the suspect what should happen to the person who committed this crime, who stole the money, who killed the victim, who raped the little girl, whatever it is. If that person says something to the effect that I think that they should be given a second chance or they should get probation or something lenient, the interrogator is automatically to presume guilt, which obviously means for all of you criminal defense lawyers out there, you never want to be on the receiving end of an interrogation because they're going to decide you're guilty immediately. And while they're doing that, they're assessing what they call their body language. using something called neuro-linguistic programming, which is just a synonym for junk science. So they have all of these ways to tell people are lying. Do you cross your legs? Do you scratch your eye? Do you scratch your hair? Are you looking down? All of which they correlate with lying, which is very interesting because some actual scientific research suggests that exactly the opposite is true. So then they look at this word choices, this body language, and they decide, aha, this person is guilty. It's time to interrogate them. And what do they do then? They start presenting false evidence. They say, what would I say to you? We have this amazing airtight case. We have DNA. We have fingerprints. We have eyewitnesses. We have you on video. And it doesn't have to be true. Not a word of it. But they make the suspect believe that they are in deep, deep trouble and there's no freaking way that they're ever going to be able to get out of it. That's their first step. And they say it by saying, what would you say if I told you, real specifically, so that when you get to a motion hearing and you're cross-examining the interrogator and you say to them, well, didn't you lie to my client? Didn't you present false evidence? He says, oh, no, counsel. I just asked them hypothetical questions. Then they begin what they call the 9 steps. It starts with confronting your client. You are guilty, no matter what. They then move in closer and closer to them, and they do what they call theme development. And you can see in this slide, what I have written down in blue, those are the really important parts of police interrogation. Now, James Trainum is going to discuss theme development in more depth, but it's usually what psychologists call minimization or maximization. In other words, first they maximize the crime, not only in terms of all this false evidence they claim to have, but also in terms of this crime is the worst, baddest, ugliest thing. In other words, you're going to go away for God knows how long. And then they offer this olive branch out with theme development, but I think you're a good guy, you had a good reason to do this, and that's what psychologists call minimization. In other words, the suspect, believing that there's no way that they can get out of trouble, should buy into this lesser version of what occurred while they cut off denials. And then eventually, when they think the person's ready to confess, they say, well, what is it? Is it choice A or choice B? Of course, they're both guilty. The suspect will pick choice B because they've implied or directly stated there's a lesser penalty. And then they start nailing down the story, and that's where contamination comes in, also through the interrogation process. And again, James Trainum is going to talk about that more. So basically, it all boils down to this. They want to persuade your client, we have a super strong case. Your situation is totally hopeless. The detective is on your side. We're your only friend, and the truth is going to help you get a lesser penalty. So let's take an example, and because people are so familiar with this, I chose to discuss the Brendan Dassey case. Now, I'm sure not all of you, but many of you have seen Making a Murderer, about Stephen Avery's conviction. And if you haven't seen it, you've probably read about it. Stephen Avery was falsely incarcerated for a rape he didn't commit for 18 years in Wisconsin, was exonerated, and 2 years later charged with the rape and murder of a young woman named Teresa Hallbach. Eventually, police, a few months afterwards, began interrogating Brendan Dassey because they believed that he was involved. Brendan Dassey was a high school student. I believe he was about 16 years old at the time. He lived on the same piece of rural property that Stephen Avery did, and eventually the police were able to get him to confess to raping, murdering, and helping to burn the body of Teresa Hallbach, which was truly a horrifying crime. So I'm going to show you a few clips. And what you have to understand is that Brendan Dassey was a limited person, developmentally disabled, and that will come through as we show you these clips about the confession. The first one is going to show you what we call false evidence ploys, I believe. In other words, things that the police tell a subject during an interrogation that are not necessarily true, but they want the suspect to believe it's true. Now, the sound quality on this first clip is very poor, but we do have all the words written. So if you can't hear, it's not your computer what's going on. It's just the quality of the video here. And you'll see how they do evidence ploys, bluff, and appeal to Brendan Dassey's emotions. Let's see what I have to do to make this come up. Okay, here we go. And I want to thank the Center for Wrongful Conviction. They are currently representing Brendan Dassey in his appeal, and they were generous enough to share these video clips with me. So what are the police doing here? They're totally bluffing. They don't know anything. They have no evidence that Brendan Dassey was there when Teresa Halbach died, but they're making it up by saying, we already know this. This is very common in police interrogations. I can't tell you how many of these interrogations I've listened to where the police say, we already know what happened. We only want to know why this happened. Now, in Brendan Dassey's case, being a juvenile, they also relied on pretending to be a parental figure. Oh wait, I'm sorry, this is the wrong one. Trying to move ahead. Not sure why, okay, hold on. Why is that happening?
Oh, you're hitting it.
Okay. Here it is, exploiting the parental dynamic.
Mark and I, yeah, we're cops. We're investigators and stuff like that, but I'm not right now. My father has a figure-raised too. You're important. I'd like more than come over and give you a hug and then overheard. Talk about it. Maybe high and dry. Talk to your mom after this. And then deal with it. Best we can. For your good, okay? I promise I was not letting you high and dry. Stand down. We both will, Brett. We're here to help you. Mom said you'd be honest with us. If she's telling you 100% know what happens here, that's what she said. Because she thinks you know we're doing. We're in your corner. We already know what happened. They'll tell us exactly. Don't lie.
So if you're wondering what you're seeing here, besides appealing to the sense that Brendan Dassey is a juvenile and is a child, the interrogation where you saw the picture of his high school, that's actually where he was talked to the first time. He was basically ordered to come out of class by the principal, because police usually engage school officials, and then brought into the principal's office and talked to. That's a whole other area that we don't have time to get into today, but there's a lot of issues that you can raise, including the involvement of schools when it comes to juveniles. This final clip, and of course everything we've been seeing has been coercive, but this will highlight a little bit more of the coercion, which, you know, the stereotype is the cops are yelling at somebody, they're threatening to beat them up. That's not what happens. Psychological coercion can sound extremely mild. again. I'm not sure what's going on here. This button? Right? Oh, on the mouse?
Yeah, right click.
I'm sorry. Okay, let's try this again. Sorry about that.
You've got people back at the sheriff's department, district attorney's office, or everything else saying there's no way that Brendan Dassey is out there and they see something. They're talking about trying to link Brendan Dassey with this event. Not saying that Brendan did it, but saying Brendan had something to do with it or cover up of it, which would mean Brendan Dassey could potentially be facing charges for that. We've gotten a lot of information. Some people don't care. Some people back there saying, well, we'll just charge him. So no, let us talk about this. You're not the opportunity to come forward with information that he has. Get it off his chest. Make it look, you can make it look however you want. But we want to go back and tell people that, Brendan told us what he knew. We want to be able to tell people that Brendan was honest. It's not like Steve. He's honest. He's a good guy. He's going to go places in this life. But in order for us to do that, you need to be honest with us. And so far, you're not being 100% honest. Mark and I both want to go back to the place. You didn't do it. Yes, he was there. He came forward. Finally, he told us. Imagine how it was waiting for him to understand that. We'll go to bat for you. But you have to be honest with us.
Mark and I looked at the tapes, looked at the notes. It's real obvious there's some places where some things were left out or maybe changed just a bit to maybe looking at yourself to protect yourself a little. From what I'm seeing, even if I fill those in, I'm thinking you're all right. Okay, you don't have to worry about things. We're there for you. And we know what Stephen did, and we know kind of what happened to you when he did. We just need to hear the whole story from you. As soon as we get that, we're comfortable with that. I think you're going to be a lot more comfortable with it. It's going to be a lot easier on you down the road if this goes to trial and stuff like that.
Honesty here, Brendan, is the thing that's going to help you. Okay, no matter what you did, we can work through that. Okay, can't make any promises, but we'll stand behind you no matter what you did. Okay, because you're being the good guy here. You're the one that's saying, you know what, maybe I made some mistakes, but here's what I did. The other guy involved in this doesn't want to help himself. All he wants to do is blame everybody else. Okay, and by you talking with us, it's helping you. Okay, because the honest person is the one saying get a better deal out of everything. You know how that works. Honesty is the only thing that'll set you free.
Oh yeah, they stood behind him all right, and I'll leave that description to your imagination at this point in time. So what do you do when you get one of these cases besides just review the interrogation? One of the most important things is your client interview, and to do that as early as possible in the case, especially if you have an interrogation case where it's not recorded, because they're very, very difficult to reconstruct. You want a really thorough social history. You need to know facts about your client. How was he arrested? What kind of food, what medications did he sleep? What was the impact of the interrogation techniques on him? If you have a tape, you can see what they did. Your client needs to describe to you how he felt. How did it reach a tipping point from your client's point of view when he gave it up and said something to the effect of, yes, I did this? What were your client's expectations about what would happen after he or she gave a confession? And what is the source of information in the statements that your client made? You need to review the interrogation. What is coerced? What's true and what's not true, and what was contaminated? So typically when I review one of these, I keep 3 running lists as I go through it and take each line in the statements that are made by the client and see which one of these categories they typically fall into. of course, we're used to litigating the issue of voluntariness. And what do we find? And I'm not going to read off the slide. You guys can read. You're intelligent. But these are the things that we look for in making a challenge to the voluntariness of the statement. It's both first showing the judge that there was some coercive conduct, and then showing the vulnerability of your client and why the police were able to manipulate them into making a confession. Because what happens during interrogations is either the police don't know about your client's vulnerabilities, or they do and they simply ignore it, or, as in the case of Brendan Dassey, they out and out exploit what their particular vulnerabilities are. And look at how Brendan Dassey, what happened with him and what he thought was going on after he gives this confession to this horrible rape murder. He didn't even realize what was going on. Look at this video of what he had to say.
Am I going to be at school before school? Probably not. I mean, we're at 2:30 already. School's over at what, 3? 3? No. What time will this be done? Well, we're pretty much done. And we have a couple of follow-up things to ask you, but it's pretty much done. Did you understand that you're under arrest now? So, I call my girlfriend to do it. Okay. We'll give you an opportunity to do that. Okay? You gotta be honest. After telling us what you told us, you gotta figure this is coming. Yeah. So we put on here. What do you think you're going? You're going to jury. That's why you're going to jury jail.
So let's talk about the motions that we can file when we have an interrogation like this. They basically come in 3 areas, and there's some others like delay in presentment to court that I'm not going to discuss here today, but they come in the categories of Miranda, voluntariness, and contamination. Litigating contamination is somewhat new. If you look in the outline that I've provided, that NACDL has given you, I have some case citations and some discussion of it. I'm going to come around to that later. Now, we all know the typical Miranda motion. They didn't read them as rights. Of course, Miranda has been terribly cut back by the U.S. Supreme Court. And so I'm just going to really briefly touch on a couple of areas with Miranda violations. First of all, how many of you have had these cases where the rights weren't read to your client because the police say, oh, well, they came in voluntarily. They weren't under arrest. They just agreed to talk to us. I'm trying to look for the right word. You know, I guess I'm going to throw out baloney, but there are other words that you might be able to think of. But how do you cross-examine a police officer under these circumstances? Because this is really not true. And so some of the suggestions I have is telling them to talk about public safety and how important it is to not have a person at liberty who is suspected of doing a horrible crime like a rape or a murder, and then talk about how they transported them, because this often starts with them coming to somebody's house or job or stopping somebody on the street and telling them, well, you need to come downtown and talk to us. In other words, ordering them. There's nothing voluntary about it. And then how did they transport your client? Get this out at the motion hearing, that this was done by putting him in the locked back of a squad car that he couldn't get out of. When they came in the police station, they didn't walk in the front door. Cross-examine them about the fact that they took them in the door where people who are in custody go. They took them on the in-custody prisoner elevator. How long it took, how long they were locked in a room. I mean, they often have them in locked rooms that they can't get out of while the police are then preparing to do their questioning. Discuss the custodial setting and get heavily into the techniques police used to break the denial. In other words, you've got to show the judge, There was absolutely nothing voluntary about this at all. One of the other techniques that they use is they often say, well, we weren't interrogating this person when they didn't read Miranda rights. We were just answering their questions, like what will happen to me? Well, there's another piece of baloney if I've ever heard it. The fact is that they are interrogating them. So once you understand and what interrogation techniques are, and that it's often a monologue by a police interrogator, that they've been trained how to do this, that they're doing using these particular techniques, and get their training materials. This is very important when you prepare for these motions. Get the training materials that show that interrogation does not really consist of asking questions. Show the judge that this is interrogation, not a response to your client's question that's very innocuous, like, well, why are you talking to me? Or what's going to happen to me? Or what are you talking about? It is an interrogation. Then there's this whole issue of right to silence. Police don't hear it. Since we got recorded interrogation in Wisconsin in 2007, I can't tell you how many tapes I have watched and listened to where at some point, not in the beginning, not during the reading of rights, but at some later point, the client says to the police interrogator, I don't want to answer any more questions. I don't want to talk about that. And they just don't hear it. It's like if they don't hear the word lawyer, they're not hearing anything. They don't hear it. We can't afford to miss it. And if this happens before your client gives his confession, especially with recorded interrogation, which is really probably the only way you can prove this, you have a really good chance at getting a suppression. The final thing that police do often, and I think this needs to be litigated more, is undermining Miranda. In other words, they read your client the rights. The client says he understands them. Of course, they've read them really, really fast. They haven't really done anything to determine that he understands them, but he says he understands them. Maybe they still even ask if he waives them. Some places do that, even though the U.S. Supreme Court says they don't have to. They're talking to your client, and the very nature of the interrogation is undermining Miranda. In other words, they're really telling them, look, you really need to talk to us, because if you don't talk to us, the prosecutor's going to look at this and he's going to be really hard on you, and they really need to hear your version. That is, in effect, undermining the protections of Miranda and telling them that Miranda doesn't count. And this is an area where there should really be, I think, more litigation, where some of the statements the police are making aren't strong enough for you to win a voluntariness claim, but you may win because they've undermined the Miranda warnings. Of course, voluntariness is a huge area for us to litigate in these motion hearings. And all of the things police do can make a confession involuntary. There's plenty of case law out there talking about that. I'm not going to bore everybody because we're all lawyers. We can go look it up. But we know it's a big area. But one of the things I do want to say, when you're litigating voluntariness, we all know that the courts are not supposed to consider whether or not this is a true or false confession when they make a decision to suppress whether something's voluntary or not. And while that's legally true, I think the subtext is really, really important. You want to send a message to the judge that this is a false confession, because judges are human beings. They don't want to suppress a confession in a horrible crime, which may well mean that the case is no good for prosecution anymore. But at least the judges who are good judges and honest judges, they don't want a false confession to be out there in front of a jury either. So you want to give the notion to the judge that this is false. And one of the ways I often do that is by challenging probable cause for the arrest. Even though there's probable cause, letting the judge know through that probable cause challenge just how weak the case was, because you can cross-examine the police who arrested your client about all the things they didn't have. They didn't have an identification. They didn't have a videotape. They didn't have an independent witness. They only had a snitch. They didn't have DNA. And whatever it is that they didn't have, you can show that the case was extremely weak, and really all they were going to have was a confession, and then point out through the motion hearing the contamination that occurred and how the confession is actually false. Now, when you do these hearings, we normally cross-examine with leading questions, but in these kinds of hearings, especially if you don't have a recording, it's very important to ask follow-up questions and ask the why question. to the police officer, why did you say this to my client? Why did you tell him that the DA would be harder on him? Because they're not used to answering questions like that from defense lawyers, and they start to slip and slide all over the place. If you are persistent, really listen, really be an active listener, and ask these kinds of questions, keep the cop talking, eventually you can show a judge that what they're saying is not really truthful. And I think that's very important, not to mention the fact that you're getting excellent discovery if you're going to end up trying the case and you don't have a recorded interrogation. Of course, these hearings with recorded interrogations are different. For those particular hearings, when you're challenging voluntariness, what you really need to produce, besides giving the court a copy of the transcript and the tape in advance, is a real specific motion hearing pointing out exactly where, line by line, the police did what they did and showing how the law does not permit that. So for me, and I think for other people in recorded interrogation jurisdictions, it's really changed how we file these motions, to the point where I've had a judge come out without an evidentiary hearing and said, "Counsel, I'm prepared to rule on this motion." And I have to tell you, it was lovely watching the prosecutor have a conniption fit when she said those words. And then she said, "Oh, of course, Mr. DA, I'll let you have a hearing." She just delayed her decision by 10 minutes, that's all. It's really important to get experts in these cases when you're challenging voluntariness and when you're challenging perhaps your client's understanding of Miranda and contamination. There are different kinds of experts that you can get. Clinical psychologists and psychiatrists are going to come in and evaluate your client. They're going to do some testing of your client. They're going to diagnose your client. They can testify about your client's particular vulnerabilities to interrogation, and you should hire somebody who's familiar with police interrogation and familiar with the studies about false confessions and the vulnerability of whether it's juveniles, people who are mentally ill. If people have a major mental disorder, I think a psychiatrist is the kind of witness you want to go with. If they are clinically, cognitively disabled, have learning disabilities, a clinical psychologist must be better. There's particular tests, psychological tests that exist that they can give your client to measure interrogative suggestibility. And then there are the social scientists and research psychologists who study the interrogation process, have in some cases, like Saul Kassan, who's pictured in the middle, done experiments, have studied through DNA exonerations, proven false confessions, who will talk about these interrogation techniques and how they can induce a false confession. And then finally, like James Trainum here, pictured in the slide and speaking today, a police practices expert who can discuss with particularity what proper police practices are and what the problems are when contamination seeps into the interrogation room, which can end up with false confessions and false statements. And then finally, so many of us are afraid to put our clients on the stand. You really should think about your client testifying when you're challenging voluntariness. Why not call them? First of all, the prosecutor can't use it in their case in chief in an actual trial. Second of all, I think it's a good opportunity to put your client on the stand. It's not the subject of today's discussion, but I'm very much in favor of telling your client's story through your client when that can be done, that the client should get up. I mean, how's the judge going to find out how he felt? By osmosis? You can't do the testifying for him. You want to let the judge know and make a connection with your client. The one thing I want to say about this is, don't say to yourself, "Oh my God, this is just a motion hearing, I'll put him on the stand." You need to work with and prepare your client so that they testify about all the things they've told you when you've been meeting with them, so they don't forget and they know that they need to answer certain questions, including the prosecutor's questions, so you should prepare them as if it was a trial. And you want to make it clear that it's not like this stereotype in this cartoon, "Your Honor, my client requests a change to give a different story." No, they're telling the truthful story when they get on the stand and explain how the police exploited them into making a false confession. Now, I'm going to turn this over now to James Trainum. He's going to discuss contamination, police interrogation, and then we'll come back and talk about litigating contamination.
Thank you. So now you have a better understanding of how we as investigators convince your client that it's a good idea to say something that could put them in jail for life, if not get them the death penalty. We're going to talk about what happens after that and how you can deal with that situation now. Now, the thing about it is that the sole goal of everything that we've been doing so far is to get a confession, to get an admission, yes, I did it. But an admission is not a confession. An admission is only, like I said, I did it. The confession part is when the detective works with your client to develop a narrative that's going to be acceptable to the detective. And it usually has to correspond with what the detective believes to be true. Now, before we get into that, there's a couple of basic things that, I've been asked about this on the stand. Just because they use coercive interrogation techniques, does that mean that the confession itself is automatically false or unreliable? And no, it's not. I mean, that's the one thing about Reed. Reed is extremely effective at getting people to tell the truth. But it's also, as a side effect, it has a higher, let's say, probability of getting them to admit to things that the detective believes to be true and needs them to incorporate into their narrative right there. So this is something that, like I said, what we're going to talk about now is how to evaluate the final confession for its actual reliability. Because just because it's accurate doesn't mean that it's reliable. And what I'm going to talk about now, you can use not only with a confession, but every single other statement that comes into your case. And the reason that you can do that is because if we don't believe somebody's telling us the truth, it doesn't matter if they're a victim, a witness, an informant, we automatically go into interrogation mode. And in fact, one of the things that Reed teaches is that if you think that a witness is lying to you, blame them. Say that they must have participated in the crime. And so all of those coercive things that could get your client to admit to a crime that they didn't commit can also be used against witnesses and victims as well. And typically, that sort of stuff is not going to come out during the let's say discovery phase or at trial itself, because by that time the witness is now cooperative. Now the thing is that Reed teaches, and we as detectives believe, that yeah, we use coercive interrogation techniques, but we can tell whether or not a confession is accurate. We can tell when somebody is giving us false information. And there's two safeguards here. One is Reed says that you never use their technique on an innocent person, so you always interrogate only the guilty people. But two is we're taught to create what we call holdback information. This is information that, as we love to say, only the real killer would know. And this is stuff that's known to the investigator right there. However, the problem is that false confessions and false witness statements contain a lot of that holdback information. And the reason that that stuff is in there is because we unintentionally, or sometimes intentionally, contaminate the interrogation. We provide that information to the person through very, very subtle means as we shape their narrative to something that we need in order to move the case forward. And so what I'm going to do now is I'm going to talk about, well, the other thing is, is that this contamination can create all different types of unreliable statement evidence. You got your totally false statements. The person wasn't there, the witness didn't see it, the person did not commit the crime. You can actually have a true statement where the contamination is so heavy that it nullifies its reliability. As an example, let's say that this is a different type of case, but let's say that you have a person who was a victim of a robbery. They're getting ready to go into the lineup room in order to see whether or not they could identify the person who robbed them. But while they're sitting outside in the waiting room, the TV news comes on and has a picture of the guy doing the perp walk down the hallway. Now, the person who's going into the lineup room, could they identify the person for real, or were they contaminated? You just don't know. And so if the contamination is so heavy during the interrogation, like I said, it could nullify any kind of true statement that comes out. Statements that criminalize a non-criminal act. Shaken baby cases where the cause of death was misdiagnosed, and the detective gets the mom to admit to a incident where maybe she shook the child just a little bit too hard. Statements that falsely increase the suspect's criminal culpability, where we're able to insert into the narrative some sort of intent purposes, taking it from an accidental to an intentional crime. And last but not least, this is what I really love, is I'm the detective. I believe that A, B, and C happened during the crime. I totally believe that to be true. However, I'm wrong about C. Well, I've just got your client to confess to A and B. But in order for that confession to be acceptable to me, because I know what the truth is, I get them to include C. And that really screws up a lot of good cases because a good defense attorney is going to be able to bring that up. That, well, how come they confess to C because C never happened? So, talking about the different forms of contamination, we talked about that holdback information. Sometimes the holdback isn't all that held back. I mean, a lot of times you have to know what's in the media, you have to know what's in the neighborhood, rumors and things like that. And I've seen cases where there's been some contamination through inference. I had this one case where this woman was murdered in a vacant building in a certain part of the city. Now, based on the victim's sex and where she was found, you can infer that there was a sexual component to this crime. Well, that was something that we didn't let out to the public, and so we were in the interview room talking to a guy about a totally different incident, and my partner said to him, "Well, hey, have you heard anything about that woman who was killed down the street?" And he goes, "Oh, the one who was raped in the building?" Yeah, my partner's eyes lit up, but it turns out that that was just inference from what he had heard in the neighborhood, and he actually had nothing to do with it right there. Question structure. We are taught time and time again, do not ask leading questions. However, that is the most common form of question that you will find in an interrogation. You know, a forced choice question, like, did you do A or B? Let's say that that your client is totally innocent, had nothing to do with this, but they've been convinced that the only way that they can escape this inevitable consequence is by giving the detective a story that they find to be acceptable. If I ask you a question, such like, let's say in a burglary that turned into a murder, if I ask you a question, how did you get out, or get in, I should say, the door or the window, I'm giving you only two options, and you can try to guess which one. There's all other ways that you can let's say, possibly get into the building, but I've narrowed it down to you to kind of make your choice easier for you. The investigator's response to answers. Now, you see this, it's a very, even the most subtle response of disappointment or questioning the person's answer can telegraph to the innocent suspect that, hey, I got the question wrong. Like the earlier question where the detective was asking, well, how did you get in, the door or the window? I know that the suspect got in through the door, but if you, as the suspect, as my suspect says, window, I'm going to go, window, and that's going to let you know that you got it wrong. Now, when you see this in a video, you'll see the innocent suspect oftentimes scrambling, trying to, let's say, correct their answer. A more common form of this manipulation is every time the suspect gets an answer wrong, they're lying. Every time they get something right, okay, now we're making progress. So basically what happens is that the shaping of the narrative, shaping of the final confession becomes like a game of 20 questions. Where bits and pieces are picked up throughout the conversation, and they're finally shaped into a narrative that's acceptable to the detective. Revealing evidence and showing crime scene photos. I mean, we're told time and time again it's a bad thing to do to show crime scene photos. However, we still do it. In fact, I was at a cold case conference where one of the leading cold case people in the country advocated that the interrogation room be made into what they call a war room with crime scene pictures all up and around it, just trying to intimidate the person as to the strength of the case. But even you have to sometimes show your evidence when you're confronting a suspect with what you feel is a discrepancy. And there's a correct way to do that. But even false evidence ploys can frequently give up information to the innocent suspect. Like in the example here, hey, witnesses saw you and another guy going through the back window. Well, I, as the detective, have just telegraphed to the suspect that, hey, one, the bad stuff happened around back, and two, you better come up with another name of somebody if you're going to get me to buy your story so that you can get me to help you out of this very, very bad situation. Theme development, we've already talked about that. Deja was talking about how they start the interrogation. We know that you did it. All we want to know is why. Well, that why part is the theme development. I'm going to suggest to you various reasons why you may have committed this crime. Now, the textbooks say that those reasons aren't supposed to imply any leniency. It's just supposed to imply a psychological or moral benefit. However, and the thing is, if you don't bite on one theme, I'm going to do another theme. But frequently, the type of themes that come out are like, look, right now the evidence looks like this is first-degree murder, but it was an accident, that sort of thing. That implies leniency, and that's one type of theme that you're not supposed to use, but we use all the time. The Reed people actually publish a book that has over 2,000 different themes for every type of crime. But if you look closely at some of those themes, they suggest a lot of the evidence that is supposed to be hold back stuff that can slip into the subject's the final narrative through contamination, such as if you're working a burglary case, you might want to suggest that, hey, you were tempted because the people were on vacation. You were tempted, or the victim should not have left the keys under the front porch, that sort of thing. Well, what have you told the person? You told the person a lot of stuff that once they finally began to give that final confession, the detective is going to start to say, hey, those were those holdback details that only the true burglar would know. And too often you see this. We just out and out tell them what we want them to say. And usually you see this a lot in longer interrogations where the detective is convinced that the person is guilty, and they become frustrated with them not cooperating, not being honest with them, and they just start giving up the information. Look, we got you, this is what we know that you did, and the person, of course, by that time is very much relieved that, okay, now I'm getting some information that I can agree to so that I won't get the death penalty or go to jail for life. There's a technique out there, I call it reverse cold reading. And actually I was showing some video clips to some law students one time of a interrogation where all this contamination was occurring. And one of the students came up to me afterwards and said, what the suspect was doing was cold reading that detective. And I go, well, what's that? And he says, look, I'm an entertainment psychic. And I go into bars and I make people believe that I know things about them that they don't. You can go online, you can look up at YouTube, there's classes in, there's books on it. And it's what, psychics do in order to convince their client that they have all this inside knowledge. Well, the suspect does this in reverse. They're desperate to convince this person that, hey, I'm cooperating with you, I'm giving you the information that you want, but I need to get something from you. A lot of times they'll give very broad, non-committal answers. In one case that I had, the suspect was believed to have stolen stuff out of a drugstore. Well, can you tell me what you stole from the drugstore? Personal items. Well, that fits the criteria for what's typically in drugstores, but it's not specific enough, but it's acceptable to me. I'll work with that. Guessing. If you watch psychics, you'll see that they guess a lot. Well, you'll see your client on the video guessing a lot. And because of verification bias, I, as a detective, if you guess wrong, you're being evasive, you're trying to protect somebody. If you guess right, that's what I'm going to remember. And that's what's going to go into my report, that you got that detail right. And so, like I said, it's a 20 questions game right there. There's also selective listening. for the first one, hearing what you want to hear, typically detectives are in there, they're guilt presumptive, they know that you did it, so they're going to look at everything through that lens right there. A really good example of this in the movies is in that movie My Cousin Vinny, where one of the kids is being interviewed by the sheriff. The kid thinks that he's being interviewed because he accidentally shoplifted a can of tuna fish. The sheriff is interrogating him because he's a suspect in a murder. And so he asks the kid, you know, when did you shoot the clerk? And the kid goes, I shot the clerk. If you remember that scene, well, in court, suddenly it's not a question, but a statement, a confession. And it's not that far off in some of these videotapes that you'll see. Gratuitous concurrence, that's something I really didn't know about until recently. That's found a lot in where people who speak English as a second language, or people who are very submissive to law enforcement or authority figures. I'll be sitting there, and you did this, and this happened, right? And the person's going to be saying, yeah. They're not acknowledging that it's true. What they're telling me is, I'm listening to you. But the detective only hears that as an admission right now. So I'm going to show you briefly a part of a film clip from our favorite case right here. Let's see, there it is. Is that it?
Yeah, going.
This is an example of contamination.
What else did you do? Did something else we know about?
He tied her up.
We know he did something else to her. What else did he do to her?
Choked her.
What else did he do to her? We know something else was done. What else did you do? Come on. Something like that. What else did you do? Come on.
What he made you do, Brendan, we know he made you do something else.
What was it? What was it?
We have the evidence, Brendan. We just need you to be honest with us.
And he called for her.
What else?
What else was done to her?
Then he punched her.
What else? What else?
He made you do something to her, didn't he? So you feel better about her being the only person, right? What did he make you do to her?
It's okay. What did you do?
Hunter. So,
What else happens to her?
Extremely intelligence. For us to believe. We know, we just need you to tell us.
that's all he did.
Alright, I'm just gonna do all this. Who shot her?
He did.
I mean, you could see how they kept pushing for more and more. He kept guessing and guessing, and finally they just came right out and told him. Now, there's basically 3 steps to getting a false confession or a false statement. First, you must think that the person, that an innocent person committed the crime, or that your witness knows something that they really don't. Second, you use coercive interrogation techniques. Third, you contaminate the confession by providing the information for the person to feed back. This is what I call the 4th step, but it's really the step that gets that confession in front of a jury. And it's what should be done by law enforcement for every single witness statement, victim statement, and confession, but it's the one thing that we kind of leave behind. And it's because confessions make for lazy cops. We got the confession, we're going to get a conviction, we just kind of move on and we don't take this step. And this is what you can do. This is the things that you can do to look at these things to help determine their reliability. And this is the type of stuff that you'll be presenting to the jury. One is basically you have to know your crime scene. You have to be able to figure out, okay, this is what we know for sure, based on an autopsy report, based on the physical evidence, or based on whatever. Once you get those facts down, and like I said, you should always be asking, how do we know what we think we know? Okay, we know the person was shot 3 times because the autopsy report said so. That is what's going to be used to evaluate. That's your holdback information. That's what's going to be used to evaluate witness statements, victim statements, and the confession at the end. And this is what I typically do anytime I get a case. I just don't want to see the confession. I want to see the entire case because I'm going to develop my own list right here. However, I started doing it backwards, and it's kind of interesting. What I'll do is I will look at the confession or the suspect or the witness statement first, and then I say to myself, okay, these are the facts that the suspect gives. If these facts are true, what would I expect to find on the crime scene? And just as an example, this was a case in D.C. where there was a witness, the only witness to this crime. She was upstairs in her bedroom looking out the window. She said that she saw Marcus and another man chasing a truck down the street, shooting at it as they ran. The truck crashed across the street from her. Marcus and the man ran up and shot the man several times through the driver's side window. So looking at the crime scene, I would expect to see probably shell casings up and down the street and also a lot of bullets going in through the driver's door. This is a picture of the crime scene. There's a pickup truck. The door was closed when the cops got there. The only bullet hole was in the very back of the back window, and it struck the victim in the head. All the shell casings were way down the block where the witness could not have seen them. However, that witness was deemed to be the government's primary witness. However, in my opinion, of course, her credibility was totally baloney. Is that the word that we're using?
I think that's
Okay.
the word we're using.
That's the word that we're using. Okay. Step 2. This is critical. This is what every detective should be trying to get with every single witness interview and every single suspect interrogation. Is there information that was not known to them that can now be corroborated? Such as, yeah, I shot the guy and I hit the gun up in the attic behind the Christmas decorations. You go up there, you find the gun, it's the gun, you test fire it. That's good stuff. Now, the problem is that a lot of times we will try to do this with witness information. We'll go back to the witness and we'll say, hey, can we corroborate this based on, what you're telling me? Now, the problem, that's a bit confusing, I kind of said it poorly. Let's say that you have a victim who says that the suspect did A, B, and C. What will happen is that the detective will interrogate the innocent suspect, get them to say that they did A, B, C, and D. The detective wants corroboration. This is new information that they didn't know. They'll go back to the victim and say, hey, the guy confessed, but he said he did D. Did he do D? And the victim goes, well, maybe he did, or damn, the guy confessed. So I might as well, be on the same page. And D gets incorporated. So you have to be very careful. Physical evidence is the best. What I love is when the detective says something like, well, yeah, they gave me information that we didn't know beforehand, like what the victim's last words were. Well, that's not something that can be corroborated if nobody else was there. But the detective makes a big deal out of it. That's really non-evidence right there, in my opinion. And third, when you look at the statement, what you're doing is, okay, they don't give up any new information, but they give up information that hold back stuff. But can you show that that information was provided without contamination? And that's where the videotape is very, very important. And that's when, you know, you have to go back and typically I use spreadsheets, and I'll go over that in just a second. I'm going to run through this other stuff. In every single statement, you're going to find stuff that just doesn't match. Often that's explained away by the detective, but on closer examination, with reliable statement clues, the information, the other information is going to pass the reliability test. You can also ask, would the missing or incorrect details increase a suspect's culpability, such as if a child was murdered and raped, but the suspect decides to leave out the rape part, and you might want to look at that at a different light. However, ones that are red flags for it being more unreliable is, are they not giving up the details because they weren't provided to them during the interrogation? The case that I was talking about, where the woman was accused of stealing stuff from a drugstore, she could provide a lot of information, but that's because I gave it to her, but she couldn't provide me with a list of the items that was stolen. And during the videotape, you could see that that information was not provided to her. If, like in our earlier example, if a child was murdered but not sexually assaulted, and the person confesses to sexually assaulting the child as well as the murder, that's a red flag. And if they can't give you those mundane, neutral details, that's a red flag as well. This breaking down the confession, this is stuff that you can do yourself, and actually this will help you during your cross-examination of the detective. I love timelines. Timelines are extremely important. It identifies when your suspect becomes when your client becomes a suspect. It identifies when certain key decisions were made, what information the detective had going into the interrogation room. And one of the things that I do to look for verification bias is I'll identify those key decision-making points. And what information did they have? What evidence did they have to make that decision? So that they get evidence A, evidence B, they determine that your client's a suspect, and then evidence C comes in. Well, I'll switch the order around. And if evidence C came in first, would they still have made that decision that your client was a suspect? You know, just switch the evidence around and see how it might have impacted the decision-making process right there. That's just an example of a timeline, just a spreadsheet that I used. Evidence charts, I use that to help me learn more about the crime scene for the crime scene analysis part, and that's just another example right there. And finally, the interview charts. Like I said, when I do evaluations of statements, I do just like Deja does. I break it down almost line for line. And what it does is it allows you to identify what coercive tactics were being used, how they impacted your client. Does he change his story after he's been told that they're going to help him 15 times? Does he suddenly start to grasp on some of the stuff, the clues that they're giving him as to what they want him to say? But the most important thing, it lets you know who says what first. Who mentions the fact that the victim was shot 3 times? Who mentions the fact that it was a .38 that was used? Is it the detective or the suspect? It's going to help you paint a picture down the road to the jury. Whose confession is it? Is it the detective who's telling the story, or is it your client? And there is just another sample of an evidence chart right there. So, and here, when you have multiple statements, especially between witnesses, I also do a chart as well to see how those statements, sometimes how they kind of develop over time. A lot of times what you'll see is a witness gives statement A, and then the suspect gives statement B, and then, like I said, witness now incorporates part of the suspect's statement into theirs. And that's, like I said, that kind of identifies narrative shifts and the potential for contamination that you can later present to the jury themselves. And that's just another chart that you really have a hard time reading. But like I said, I love spreadsheets. I'm very visual. And I think that most jurors are also very visual as well. And so now we're going to kind of sit down here and chat together.
One of the things that I really want to talk about with everybody is this issue of suppressing evidence due to contamination. So let's just start out and say that if you're researching your case law, which of course we all do before we file motions, and you're going to research, well, what court suppressed a confession because it was so contaminated it shouldn't be allowed into evidence, you're basically not going to find a whole lot. You're going to find a few citations that refer to contamination as part of a voluntariness analysis. But I encourage people to think about this, about contamination, and whether or not courts should not allow a statement in because it is in fact so contaminated, it's not really your client's statement or the witness's statement. It's what the police told your client to say through the interrogation process. So, we all, wherever we practice, have some version of Rule 403. In other words, only probative evidence should be able to be admitted into court. But when that probative evidence's value is substantially outweighed by the danger of unfair prejudice, a court has a gatekeeping function to not allow that into evidence. There's some case law to support this, not much, but a little bit in the eyewitness identification area. And when Colette was talking in her introduction about this motion, the judge actually suppressed an eyewitness identification because of its lack of reliability. It wasn't contaminated by police in that particular case, but it was found to be inherently unreliable. So what about a confession that's not reliable? Should it be allowed into evidence when there's nothing really that a juror should relate to? And that's where I think it's really an idea to use a police practices expert like James Trainum to come in to your courtroom and talk about the fact that this confession has no reliability whatsoever. It is completely contaminated by the police. You're going to need a transcript of what really happened. So this is a motion that really is viable when you have a recorded interrogation, and you're going to need some expert witnesses. One of the things I think that we really need to think about in these cases is trial before plea. And this is happening less these days. These days, when I talk to lawyers around the country about their confession cases, what I'm usually hearing people say is, my client says it's a false confession. How can I litigate this? But unfortunately, I'm still hearing lawyers say, oh, my client gave a full confession. It's going to be a plea case. We need to think about trial before plea. How is it that we can defend these cases and try these cases when our clients tell us this is a false confession? So what are we going to do? Because this picture here, I think, really is what our clients are facing. Everybody is pointing the finger at them and saying, what are you doing having a trial? You gave a confession in this particular case.
And with this, the Reed people who teach this technique, who are the biggest proponents of coercive interrogation tactics, they can be your friend. Because, back in 1983, Reed published their third edition. It mentioned almost nothing about false confessions. Since then, they published two more. They've doubled in size. And they have a ton of stuff in there that is really, really, really good for you to bring up during trial, especially if your detective was retrained. Even if they're not retrained, Reed is considered by experts and other people to be the standard. And this is stuff that when you talk about it in front of a jury, it's stuff that they can actually understand. The fact, and you can also relate it to everyday life. Show how an interrogation is like a high-pressure sales tactic that we've all fallen victim to, that we've all had this temporary perception that, yeah, it's a good idea to take out that payday loan at such a high interest, not realizing what the consequences are at the end. Reed teaches all the stuff that I talked about cooperation. Reed has it in their textbook. They have in their handout material that you should not use implied threats or implied promises, all that stuff. The thing about it is, what helps you, it doesn't help your client, but what helps you is that this stuff never makes it into the classroom. People who take the training, it's like a 3 or 4 day training. This stuff is downplayed, it's minimized, but it's there, and it's there for you to use. And when we've worked together, and I've worked with other attorneys, a lot of times what we do is we kind of paint the picture when it comes to the confession, the contamination part, and we let the jury kind of figure it out for themselves. We kind of walk them down the path, and then they come to the a realization that, hey, there's a problem here. These guys didn't follow basic investigative procedures 101. My job is to kind of lay out, this is what cops do. This is what we do on a day-to-day basis, and it wasn't done here.
One of the things that I think is really important is it's great to have an expert, and I think you really need an expert in these cases, but don't just rely on the expert. How you cross-examine the police officers in these particular cases is really, really important. And in every case where I'm going to mount an attack on police officers and what they did, I go and get their training records. Now, that earlier slide that we were showing you here just a minute ago is a trial that occurred in Wisconsin earlier this year, where James Trainum came in and talked about not a client's confession, but actually about statements by witnesses that were coerced by the police. And what they were doing here was unbelievable. They were telling these witnesses, if you don't tell us who did it, we're going to put you away for life. Literally saying that in the transcript. So this was a really good case for Jim Trainum to come in and talk about coercive police interrogation techniques. There was also some contamination that occurred where they basically told one of these witnesses what kind of bullet was used that the victim was shot with, so that the jury understood. And you know that your jury is not believing what's going on in a police interrogation when you're cross-examining a police officer who's slipping and sliding all over the place, and the jurors are going like this, oh my God, and they're rolling their eyes. You know you've got your jury then. Unfortunately, cases may have other issues that could lead to your clients being found guilty, but setting that issue aside, get their records. Cross-examine them early on about the fact that they went to training and learned various things in training. I always start by asking them about how they learned how to use their gun, because they have to take training on how to use a gun, how to clean a gun, how the mechanics of a gun work, but also shoot, not shoot. That's a very important part of police training. Jurors don't like police officers who don't follow their training on how to use a lethal weapon. After that, you get them to admit that training is important. They use their training. Later on, they're invariably going to say that they didn't rely on their training for how to take confession. They relied on their experience and their on-the-job training. I don't know, I've cross-examined so many police officers on this, and I have to tell you, and talk to so many lawyers in the country, from sea to shining sea, police are going to say that they relied on their experience and their training didn't really matter. Well, how are you going to contrast with them earlier saying that their training was very important? And what is this cop anyways? If he's following his training, you can use the training records to show how the training materials that they were actually given told them to do things like not contaminate a confession. They're taught to use to have holdback facts, to not tell the suspect the facts, that there are dangers with doing that. Then you show in the confession how they actually did contaminate the confession, and it didn't follow their training. Well, if they say they followed their training, then their training told them not to do it. If they say they didn't follow their training, what do you have, ladies and gentlemen of the jury? Rogue cop.
Plus, what you can do is, like I said, equate the confession to other aspects of personal life and also other aspects of investigation. Detective, you're trained not to contaminate evidence by putting the suspect's clothing in with the victim's clothing, right? You're trained to wear gloves. You're trained to do this. You know what contamination is. Why didn't you follow that training here? It's obvious what's going on. Something else with timelines. As you see how an interrogation is structured, it's not trying to get the suspect to tell the truth. It's trying to get them to conform to a narrative that the detective wants. You can show how this, I'm searching for the truth. Well, if you're searching for the truth, how come you kept suggesting all these things to my client? How come you're the one who's talking 90% of the time and my client's only, just saying, I didn't do it. Just show how tunnel vision has taken over, how they've rushed to judgment, and they just wanted to get this behind them.
That's one of the things that really happened in that clip that you were playing from the Brendan Dassey case. We see the police officer over and over saying, what happened with the head? What happened with the head? Well, the interesting thing in the Brendan Dassey case, and a lot of people may not realize this even if they've seen the Making a Murder documentary, is in the previous occasions when they questioned Brendan Dassey back at the school, and there's one that we didn't play clips from that occurred in the police department a couple of days before this one, the police did not know that Teresa Hallback had been shot in the head. That was not their belief at that particular time. The day before this interrogation, they get information from, I assume it's a forensic anthropologist or forensic pathologist, whoever it is, that lets them know that she was in fact shot in the head. That hadn't been in any previous statement. So they come in and they have to nail this down, and they have to get a completely different story in this interrogation from Brendan Dassey. What happens? He's not giving it to them, so they basically have to tell him what occurs. And you'll see that in these interrogations. Sometimes it's subtle, sometimes it's not so subtle, but it's definitely something that you want to look for.
And even if you don't have a videotape of the entire interrogation, a lot of times, a lot of agencies will still interrogate for X number of hours and do that final recap video there of the final confession. You can still take a lot of what we've talked about and apply it to evaluating that confession as well. Just like I said, do the details match the crime scene? Is the person, a lot of times the person, you'll see the person being coached because they will have forgotten part of the stuff that they were supposed to include it. So the detective will say, well, didn't you say before? And kind of coach them and hint and give them clues as to where things that they should be adding to that final version right there. So just because it's not totally videotaped, not all hope is lost. You still have a lot to work with.
That's good because it's a lot less.
It's a lot less.
It's a lot less.
It's a lot less, but there's still potential there. Something else I like to do too is when it's not videotaped, I like to go back and try to find other cases where the detective has had problematic interrogations and see what their cross-examination was there or their testimony there.
That's an excellent suggestion. You know, before we had recording interrogation in Wisconsin, I had a case where a client told me about a certain technique the detective used in his interrogation. I won't get into all the details because the story is too long. But what I did when I heard that was I tried to find the case and I couldn't. So, you know, and this is for you, for those of you especially in public defender offices or wherever you practice, I sent a letter out to not only our staff, but all of the lawyers on our panel, private practitioners in Milwaukee, asking them, have you ever had this police officer? And have you ever, can you tell me a little bit about how they interrogated your client? Well, one of the people wrote back to me, the cop had used the exact same interrogation technique that he had used with my client, and this lawyer had had a motion to suppress, so we got the transcript. We knew exactly what his answers were going to be to all the questions about why he did what he did going in to the suppression hearing. Suppression hearings where you don't have a recording are very lengthy. You have to really recreate the interrogation. But the police, if you have a good judge and you keep the police on, and sometimes these hearings, I've done some that have stretched to like 2 weeks of actual, not, I mean, the judge had other calendar, but they took place, you know, it took longer to recreate an interrogation in court than the 27 hours of interrogation that actually occurred. The police will mess it up. They have messed it up, and sometimes the judges can see that, and they believe your client and find that the confession was actually coerced.
But doing that, my argument has always been, once we find something that works for us, we keep using it. If you know somebody, like I'll watch detectives who I've worked with for years, and I can almost say what they're going to say word for word next, because I've seen so many of them. They're going to go through the same routine and all that. And so that's been my argument when I try to bring in another case to compare to this one.
You know, I just want to say a few words about trying these cases to juries and some things that are persuasive. One of the benefits that we have since Making a Murder has come out is a lot of people have seen it, and if they haven't seen it, they've heard or they've read about it. It's really something worth voir diring on. And I know a lot of prosecutors are actually asking jurors in the jury selection process whether they've seen it. But one of the things that we can do is use our technique of jury deselection, especially when you're practicing in places where judges are not giving you a lot of time for voir dire. So the questions that we're asking all the time now of jurors, besides who's seen making a murder, instead of asking them what they thought, the question that I'm asking in voir dire and other lawyers in my office are asking is, who here saw making a murder and thinks the police were given a raw deal or treated unfairly? Or even if they haven't seen the documentary because they've read about it. Now, this may be much more in Wisconsin, they've read about it. There's been a lot of press on it as the police and prosecutors defend themselves. But if you have jurors who say, I think the police were given a raw deal, it wasn't really fair to them, it didn't tell their side, that could be a really good sign that you need to strike this person. And if you're only being given a half an hour to voir dire your jury, as so many judges are impatiently doing, that can be a key question for jury deselection. You've got to find out what jurors think about police conduct and false statements and before you get into the jury room. You want to know now during the jury selection process. Another thing that is really, really important in trial is that you've got to make this a centerpiece of your opening statement. There's no shying away from that confession. It exists. It's going to be out there front and center, or false statements by witnesses. Talk about it from minute one. Think about playing parts of it in your opening statement and showing the jurors right away, this was contaminated. This isn't really my client's statement. This is the police interrogator's statement. This is what's going on in this case. We know from all kinds of studies that 80% of the time, jurors will come back with the same verdict that they thought they might be inclined to have after the opening statements. Doesn't necessarily mean that their mind is completely made up, but it's very, very persuasive. You know what you're going to cross-examine the interrogating police officers on. You know they're going to waffle and wiggle and try to get away from you, and that a cross that might have taken 30 minutes can end up taking 3 hours, as they frequently do, because they just can't bear to say the word yes when a defense lawyer is asking the question. You know it's all going to happen, but you know in the essence what you're going to get out of a cross. Tell them in the opening statement so that when the detective gets up to testify for the prosecutor, your jurors are already skeptical about what they're hearing. And then when you get up and do your cross, you're confirming that for them. See, this is what happens. That way you have faith with your jury and it's not surprising. When you're going to win one of these cases, you need to really win it before you even get to the closing argument by persuading and your jurors understanding that this is not a truthful confession.
And just one thing, when it comes to police practice experts and all of that, they're good. Sometimes you can't get one, sometimes the judge won't let them in, but there's nothing that I can say that a lot of times you can't get out yourself. And I've actually, more of my successful cases have been the result of the attorneys doing great cross-examinations because they know the material, they know the training, they know what to look for, they have their charts. And I know 4 or 5 cases right now where they got acquittals on cases where 10 years ago they would never have thought of getting acquittals.
That's very true. So I think that we do understand and we do realize that we can actually challenge this confession evidence. And we need to get out there and start doing that. One of the things that I also want to add about experts is you might be able to get a police practices expert in where you can't necessarily get a false confession research psychologist in. Unfortunately, there's a number of different court decisions around the country that have barred this type of testimony under Daubert, or have upheld at least judges refusing to allow it in. It's a mixed picture around the country, but it's not that good. It's very easy for us to get in experts who are clinical psychologists or psychiatrists who've interviewed the client and can talk about their particular vulnerability. There are really good court decisions. But some of the courts are borrowing experts like Dr. Saul Caston or Dr. Richard Leo. When James Trainum came to testify in Wisconsin, the district attorney, after she saw his curriculum vitae, didn't even put up a Daubert fight, but conceded that he was an expert in the area. If she had fought it, I think the judge would have allowed it in anyways. But the police are essentially testifying as quasi-experts when they talk about the interrogation and the confession, and you have a much better chance that the judge is going to allow in a qualified former police officer who can analyze what happened and talk about what police procedures are when the detectives themselves are defending their procedures while they testify. Now, I think we're getting ready to end this seminar. I don't know if we have any questions from anybody. I guess not at this particular point, but so I just want to close this with a couple of things. One, I can't tell you, and I'm sure you all know this, all you criminal defense lawyers out there, how important it is to really be a true believer. You know, we communicate how we feel to jurors, and they see our sincerity and our belief. And the great thing about it, it's contagious. So don't be cynical about these cases. You know, we all have heard this phrase, trial psychosis. It's true and it's wonderful. But we have to really believe, you know, innocent people walk through our door and they tell us, I confess to something I didn't do. It's so counterintuitive, it can even be hard for us as criminal defense lawyers to believe this. We have to examine our own biases and our own preconceived ideas about what happened. It's our job to go out and fight like hell for that client and to really believe in their case and in their cause and to bring it to the jurors' attention, because we get acquittals that way and then we may just end up like this little guy.
So thank you very much. That was wonderful. I'm a 2004 graduate of the Reed School of Interrogation. After I spoke with James Trainum a couple months ago, I was encouraged to buy the most recent edition of the Reed Interrogation Technique book. It's volume 5. Mm-hmm. And I encourage everyone to buy that book. Or even do the online course, because it is the difference after you've completed the Reed school or you've read the Reed book, how you approach these cases, how you cross-examine the detectives, and how you talk to judges and juries is forever changed. So thank you for both, for you encouraging me in 2004 and for you encouraging me to continue my education
here.
Yeah.
So thank you all for participating in this online webinar. It will be hosted on NACDL's webpage, so if you want to rewatch it, you certainly can do so. I also would encourage you, if you're not NACDL members, to consider joining the National Association of Criminal Defense Lawyers. We are an organization that is really helpful to public defenders, criminal defense lawyers nationwide. Not only do we provide top-notch live CLEs, webinars, access to reports, research, and research counsel. We are an organization that wants to be there for you whenever you are facing these very, very difficult cases, especially in the environment that we're living in 2016. If you want to sign up for our annual conference, which will be held in Palm Beach in Florida, there is still space available. Deja, Vishny, and myself will both be speaking there. Deja, the title of the conference is Winning Even When They Cheat. So we'll be talking about the challenges of judges, jurors, prosecutors, law enforcement, etc. If you join as a public defender, there's also a discounted rate for full-time public defenders. So thank you very much for taking your time to watch this amazing webinar, and I hope that we can provide very interesting webinars in the coming months. So thank you.